Part 1. The subjective conditions of evidence, the mental activities of the judge. Title A. The conditions of taking evidence. Topic 1. Method. Section A. General considerations. Socrates, dealing in the Meno with the teachability of virtue, sends for one of Meno's slaves to prove by him the possibility of absolutely certain a priori knowledge. The slave is to determine the length of a rectangle, the contents of which is twice that of one measuring 2 feet. But he is to have no previous knowledge of the matter, and is not to be directly coached by Socrates. He is to discover the answer for himself. Actually, the slave first gives out an incorrect answer. He answers that the length of a rectangle having twice the area of the one mentioned is 4 feet, thinking that the length doubles with the area. Thereupon Socrates triumphantly points out to Meno that the slave does, as a matter of fact, not yet quite know the truth under consideration, but that he really thinks he knows it. And then Socrates, in his own Socratic way, leads the slave to the correct solution. This very significant procedure of the philosopher is cited by Guggenheim as an illustration of the essence of a priori knowledge, and when we properly consider what we have to do with a witness who has to relate any fact, we may see in the Socratic method the simplest example of our task. We must never forget that the majority of mankind dealing with any subject whatever always believe that they know and repeat the truth. And even when they say doubtfully, "I believe, it seems to me," there is, in this tentativeness, more meant than meets the ear. When anybody says, "I believe that," it merely means that he intends to insure himself against the event of being contradicted by better informed persons, but he certainly has not the doubt his expression indicates. When, however, the report of some bare fact is in question, "It rained," "It was o'clock," "His beard was brown," or "It was o'clock," it does not matter to the narrator, and if he imparts such facts with the introduction, "I believe," then he was really uncertain. The matter becomes important only where the issue involves partly concealed observations, conclusions, and judgments. In such cases another factor enters, conceit, what the witness asserts he is fairly certain of just because he asserts it, and all the "I believes," "perhapses," and "it seems" are merely insurance against all accidents. Generally, statements are made without such reservations, and even if the matter is not long certain, with full assurance. What thus holds of the daily life holds also, and more intensely, of court witnesses, particularly in crucial matters. Anybody experienced in their conduct comes to be absolutely convinced that witnesses do not know what they know. A series of assertions are made with utter certainty. Yet when these are successively subjected to closer examinations, tested for their ground and source, only a very small portion can be retained unaltered. Of course, one may here overshoot the mark. It often happens, even in the routine of daily life, that a man may be made to feel shaky in his most absolute convictions by means of an energetic attack and searching questions. Conscientious and sanguine people are particularly easy subjects of such doubts. Somebody narrates an event. Questioning begins as to the indubitability of the fact, as to the exclusion of possible deception. The narrator becomes uncertain. He recalls that, because of a lively imagination, he has already believed himself to have seen things otherwise than they actually were, and finally he admits that the matter might probably have been different. During trials, this is still more frequent. The circumstance of being in court of itself excites most people. The consciousness that one's statement is, or may be, of great significance increases the excitement, and the authoritative character of the official subdues very many people to conform their opinions to his. What wonder, then, that however much a man may be convinced of the correctness of his evidence, He may yet fail in the face of the doubting judge to know anything certainly. Now, one of the most difficult tasks of the criminalist is to hit, in just such cases, upon the truth, neither to accept the testimony blindly and uncritically, nor to render the witness, who otherwise is telling the truth, vacillating and doubtful. But it is still more difficult to lead the witness, who is not intentionally falsifying, but has merely observed incorrectly or has made false conclusions, to a statement of the truth as Socrates leads the slave in the Meno. It is as modern as it is comfortable to assert that this is not the judge's business, that the witness is to depose, his evidence is to be accepted, and the judge is to judge. Yet it is supposed before everything else that the duty of the court is to establish the material truth, that the formal truth is insufficient. Moreover, if we notice false observations and let them by, then, under certain circumstance, we are minus one important piece of evidence pro and con, and the whole case may be turned topsy-turvy. At the very least, a basis of development in the presentation of evidence is so excluded. We shall, then, proceed in the Socratic fashion. But, inasmuch as we are not concerned with mathematics, and are hence more badly placed in the matter of proof, we shall have to proceed more cautiously and with less certainty than when the question is merely one of the area of a square. On the one hand, we know only in the rarest cases that we are not ourselves mistaken, so that we must not, without anything further, lead another to agree with us. On the other hand, we must beware of perverting the witness from his possibly sound opinions. It is not desirable to speak of suggestion in this matter, since, if I believe that the other fellow knows a matter better than I and conform to his opinion, there is as yet no suggestion, and this pure form of change of opinion and of openness to conviction is commonest among us. Whoever is able to correct the witness's apparently false conceptions, and to lead him to discover his error of his own accord, and then to speak the truth, whoever can do this, and yet does not go too far, deducing from the facts nothing that does not actually follow from, that man is a master among us. Section B. The method of natural science, Botneau. If now we ask how we are to plan our work, what method we are to follow, we must agree that to establish scientifically the principles of our discipline alone is not sufficient. If we are to make progress, the daily routine also must be scientifically administered. Every sentence, every investigation, every official act must satisfy the same demand as that made of the entire juristic science. In this way, only zero can we rise above the mere workaday world of manual labor, with its sense-dulling disgust, its vexatious monotony, and its frightful menace against law and justice. While jurists merely studied the language of dead laws, expounding them with effort unceasing, and one may complain, propounding more, we must have despaired of ever being scientific. And this because law as a science painfully sought justification in deduction from long obsolete norms, and in the explanation of texts. To jurisprudence was left only the empty shell, and a man like Eye-Herring spoke of a circus for dialectico-acrobatic tricks. Yet the scientific quality is right to hand. We need only to take hold of the method that for nearly a century has shown itself to us the most helpful. Since Warnkonig told us, jurisprudence must become a natural science, men have rung changes upon this battle cry, Cfl. Spitzer. And even if, because misunderstood, it led in some directions wrongly, it does seem as if a genuinely scientific direction might be given to our doctrines and their application. We know very well that we may not hurry. Wherever people delayed in establishing the right thing and then suddenly tried for it, they went in their haste too far. This is apparent not only in the situations of life, it is visible, in the very recent hasty conclusions of the Lombrosists, in their very good but inadequate observations, and unjustified and strained inferences. We are not to figure the scientific method from these. It is for us to gather facts and to study them. The drawing of inferences we may leave to our more fortunate successors. But in the daily routine we may vary this procedure a little. We draw their particular inferences from correct and simple observations. From facts to ideas, says Oettingen. The world has for several millenniums tried to subdue matter to preconceptions, and the world has failed. Now the procedure is reversed. From facts to ideas, there lies our road. Let us for once observe the facts of life without prejudice, without maxims built on preconceptions. Let us establish them, strip them of all alien character. Then finally, when we find nothing more in the least doubtful, we may theorize about them and draw inferences modestly and with caution. Every fundamental investigation must first of all establish the nature of its subject matter. This is the maxim of a book, Über die Dummheit, one of the wisest ever written. The same axiomatic proposition must dominate every legal task, but especially every task of criminal law. It is possible to read thousands upon thousands of testimonies and to make again this identical, fatiguing, contrary observation. The two, witness and judge, have not defined the nature of this subject. They have not determined what they wanted of each other. The one spoke of one matter, the other of another, but just what the thing really was that was to have been established, the one did not know, and the other did not tell him. But the blame for this defective formulation does not rest with the witness. Formulation was the other man's business. When the real issue is defined, the essentially modern and scientific investigation begins. Ebbinghaus, I believe, has for our purpose defined it best. It consists in trying to keep constant the complex of conditions demonstrated to be necessary for the realization of a given effect. It consists in varying these conditions, in isolating one from the other in a numerically determinable order, and finally in establishing the accompanying changes with regard to the effect in a quantified or countable order. I cannot here say anything further to show that this is the sole correct method of establishing the necessary principles of our science. The aim is only to test the practicality of this method in the routine of a criminal case, and to see if it is not, indeed, the only one by which to attain complete and indubitable results. If it is, it must be of use not only during the whole trial, not only in the testing of collected evidence, but also in the testing of every individual portion thereof, analyzed into its component elements. Let us first consider the whole trial. The effect is here the evidence of A's guilt. The complex conditions for its establishment are the collective instruments in getting evidence. The individual conditions are to be established by means of the individual sources of evidence, testimony of witnesses, examination of the premises, abduction, protocol, etc. The constantification of conditions now consists in standardizing the present instance. Thus, whenever similar circumstances are given, i.e., the same instruments of evidence are present, the evidence of guilt is established. Now the accompanying changes with regard to the effect, i.e., proof of guilt through evidence, have to be tested. Therefore, the individual conditions, i.e., the individual sources of evidence, have to be established and their values to be determined and varied. Finally, the accompanying change in effect, conviction by evidence, is to be tested. The last procedure requires discussion. The rest is self-evident. In our business, isolation is comparatively easy, inasmuch as any individual statement, any visual impression, any effect, etc., may be abstracted without difficulty. Much harder is the determination of its value. If, however, we clearly recognize that it is necessary to express the exact value of each particular source of evidence, and that the task is only to determine comparative valuation. The possibility of such a thing, in at least a sufficiently close degree of certainty, must be granted. The valuation must be made in respect of two things: its reliability, subjective and relative; its significance, objective and absolute. On the one hand, the value of the evidence itself must be tested according to the appraisement of the person who presents it and of the conditions under which he is important. On the other, what influence evidence accepted as reliable can exercise upon the effect considered in and for itself. So then, when a testimony is being considered, it must first be determined whether the witness was able and willing to speak the truth, and further, what the importance of the testimony may be in terms of the changes it may cause in the organization of the case. Of greatest importance and most difficult is the variation of conditions and the establishment of the changes thereby generated, with regard to the effect, i.e., the critical interpretation of the material in hand. Applied to a case, the problem presents itself in this wise. I consider each detail of evidence by itself and clear it of all others, and I vary it as often as it is objectively possible to do so. Thus I suppose that each statement of the witness might be a lie, entirely or in part. It might be incorrect observation, false inference, etc. And then I ask myself, does the evidence of guilt, the establishment of an especial trial, now remain just? If not, is it just under other and related possible circumstances? Am I in possession of these circumstances? If now the degree of apparent truth is so far tested that these variations may enter and the accusations still remain just, the defendant is convicted, but only under these circumstances. The same procedure here required for the conduct of a complete trial is to be followed also, in miniature, in the production of particulars of evidence. Let us again construe an instance. The effect now is the establishment of the objective correctness of some particular point, made by statements of witnesses, looks, etc. The complex of conditions consists in the collection of these influences, which might render doubtful the correctness, i.e., dishonesty of witnesses, defective examination of locality, unreliability of the object, ignorance of experts, etc. It is necessary to know clearly which of these influences might be potent in the case in hand, and to what degree. The standardization consists, also this time, in the comparison of the conditions of the present case with those of other cases. The variation, again, consists in the abstraction from the evidence of those details which might possibly be incorrect, thus correcting it from various points of view, and finally in observing the effect as it defines itself under this variety of formulation. This procedure, adopted in the preparation and judgment of each new piece of evidence, excludes error as far as our means conceivably permit. Only one thing more is needful: a narrow and minute research into that order of succession which is of indispensable importance in every natural science. Of all truths concerning natural phenomena, those which deal with the order of succession are for us the most important. Upon a knowledge of them is grounded every intelligent anticipation of the future. J.S. Mill. The oversight of this doctrine is the largest cause of our failures. We must, in the determination of evidence, cleave to it. Whenever the question of influence upon the effect is raised, the problem of order is found invariably the most important. Mistakes and impossibilities are in the main discovered only when the examination of the order of succession has been undertaken. In short, we have confined ourselves long enough to the mere study of our legal canons. We now set out upon an exact consideration of their material. To do this obviously demands a retreat to the starting point and a beginning we ought to have made long ago. But natural sciences, on which we model ourselves, have had to do the identical thing and are now at it openly and honestly. Ancient medicine looked first of all for the universal panacea and boiled theriac. Contemporary medicine dissects, uses the microscope, and experiments, recognizes no panacea, accepts barely a few specifics. Modern medicine has seen the mistake. But we lawyers boil our theriac even nowadays and regard the most important study, the study of reality, with arrogance. Topic 2. Psychologic Lessons. Section A. General Considerations. Of the criminalist's tasks, the most important are those involving his dealings with the other men who determine his work, with witnesses, accused, jurymen, colleagues, etc. These are the most pregnant of consequences. In every case, his success depends on his skill, his tact, his knowledge of human nature, his patience, and his propriety of manner. Anybody who takes the trouble may note speedily the great differences in efficiency between those who do and those who do not possess such qualities. That they are important to witnesses and accused is undoubted, but this importance is manifest to still others. The intercourse between various examining judges and experts is a matter of daily observation. One judge puts the question according to law and expects to be respected. He does not make explicit how perfectly indifferent the whole affair is to him, but experts have sufficient opportunity to take note of that fact. The other narrates the case, explains to the experts its various particular possibilities, finds out whether and what further elucidation they demand, perhaps inquires into the intended manner and method of the expert solution of the problem, informs himself of the case by their means, and manifests a special interest in the difficult and far too much neglected work of the experts. It may be said that the latter will do their work in the one case as in the other, with the same result. This would be true if, unfortunately, experts were not also endowed with the same imperfections as other mortals, and are thus far also infected by interest or indifference. Just imagine that besides the examining magistrate of a great superior court, every justice and, in addition, all the chiefs and officials manifested equal indifference. Then even the most devoted experts would grow cool and do only what they absolutely had to. But if all the members of the same court are actuated by the same keen interest and comport themselves as described, how different the affair becomes. It would be impossible that even the indifferent and perhaps least industrious experts should not be carried out of themselves by the general interest, should not finally realize the importance of their position and do their utmost. The same thing is true of the president, the jurymen, and their fellow judges. It is observable that here and there a presiding justice succeeds in boring all concerned during even criminal cases interesting in themselves. The incident drags on, and people are interested only in finally seeing the end of the matter. Other presiding justices again, fortunately the majority, understand how to impart apparent importance to even the simplest case. Whatever office anybody may hold, he and his mates are commissioned in the common task, and should the thing come up for judgment, everybody does his best. The difference here is not due to temperamental freshness or tediousness. The result depends only upon a correct or incorrect psychological handling of the participants. The latter must in every single case be led and trained anew to interest, conscientiousness, and cooperation. In this need lies the educational opportunity of the criminal judge. Whether it arises with regard to the accused, the witness, the associate justice, or the expert is all one. It is invariably the same. That knowledge of human nature is for this purpose most important to the criminalist will be as little challenged as the circumstance that such knowledge cannot be acquired from books. Curiously enough, there are not a few on the subject, but I suspect that whoever studies or memorizes them, such books as Pachel's, Hertz's, Meister's, Engel's, Jesoic's, and others, enumerated by Volkmar, will have gained little that is of use. A knowledge of human nature is acquired only, barring of course a certain talent thereto, by persevering observation, comparison, summarization, and further comparison. So acquired, it sets its possessor to the fore, and makes him independent of a mass of information with which the others have to repair their ignorance of mankind. This is to be observed in countless cases in our profession. Whoever has had to deal with certain sorts of swindlers, lying horse traders, antiquarians, prestidigitators, soon comes to the remarkable conclusion that of this class, exactly those who flourish most in their profession and really get rich understand their trade the least. The horse dealer is no connoisseur whatever in horses. The antiquarian cannot judge the value nor the age and excellence of antiquities. The card sharp knows a few stupid tricks with which, one might think, he ought to be able to deceive only the most innocent persons. Nevertheless, they all have comfortable incomes, and merely because they know their fellows and have practiced this knowledge with repeatedly fresh applications. I do not, of course, assert that we criminalists need little scholarly knowledge of law and ought to depend entirely upon knowledge of men. We need exactly as much more knowledge as our task exceeds that of the horse dealer, but we cannot do without knowledge of humanity. The immense onerousness of the judge's office lies in just the fact that he needs so very much more than his bare legal knowledge. He must, before all things, be a jurist, and not merely a criminalist. He must be in full possession not only of the knowledge he has acquired in his academy, but of the very latest up-to-date status of his entire science. If he neglects the purely theoretical, he degenerates into a mere laborer. He is in duty bound not only to make himself familiar with hundreds of things, to be able to consort with all sorts of crafts and trades, but also, finally, to form so much out of the material supplied him by the law as is possible to human power. Section B. Integrity of witnesses. One of the criminal judge's grossest derelictions from duty consists in his simply throwing the witness the question and in permitting him to say what he chooses. If he contents himself in that, he leaves to the witness's conscience the telling of the truth and the whole truth. The witness is, in such a case, certainly responsible for one part of the untruthful and suppressed, but the responsibility for the other and larger part lies with the judge who has failed to do his best to bring out the uttermost value of the evidence, indifferently for or against the prisoner. The work of education is intended for this purpose, not, as might be supposed, for training the populace as a whole into good witnesses, but to make that individual into a good, trustworthy witness who is called upon to testify for the first and perhaps for the last time in his life. This training must in each case take two directions. It must make him want to tell the truth. It must make him able to tell the truth. The first requirement deals not only with the lie alone, it deals with the development of complete conscientiousness. How to face the lie itself cannot be determined by means of training, but conscientious answers under examination can certainly be so acquired. We are not here considering people to whom truth is an utter stranger, who are fundamentally liars, and whose very existence is a libel on mankind. We consider here only those people who have been unaccustomed to speaking the full and unadulterated truth, who have contented themselves throughout their lives with, approximately, and have never had the opportunity of learning the value of veracity. It may be said that a disturbingly large number of people are given to wandering in conversation and in the reproduction of the past. They do not go straight, quickly, and openly to the point. They loiter toward it. If I do not reach it in a beeline, I can get along on bypaths, if not today, then tomorrow. And if I really do not get to it at all, I do get somewhere else. Such people have not homes but inns. If they are not in one place, another will do. These persons are characterized by the event that whenever one has seen their loitering and puts the matter to them with just anger, they either get frightened or say carelessly, "Oh, I thought this was not so accurate." This famine of conscience, this indifference to truth, does far-reaching damage in our profession. I assert that it does immensely greater harm than obvious falsehood, because indeed, the unvarnished lie is much more easily discoverable than the probable truth which is still untruth. Moreover, lies come generally from people with regard to whom one is, for one reason or another, already cautious, while these insinuating approximations are made by people who are not mistrusted at all. The lack of conscientiousness is common to all ages, both sexes, and to all sorts and conditions of men. But it is most characteristically frequent and sharply defined among people who have no real business in life. Whoever romances in the daily life, romances when he ought to be absolutely truthful. The most dangerous of this class are those who make a living by means of show and exhibition. They are not conscienceless because they do nothing worthwhile. They do nothing worthwhile because they are conscienceless. To this class belong peddlers, street merchants, innkeepers, certain shopkeepers, hack drivers, artists, etc., and especially prostitutes, cf. Lombroso, etc., etc. All these people follow a calling perhaps much troubled, but they do no actual work, and have chosen their profession to avoid regular, actual work. They have much unoccupied time, and when they are working, part of the work consists of gossip, part of loafing about, or of a use of the hands that is little more. In brief, since they loiter about and make a profit out of it, it is no wonder that in giving evidence they also loaf and bring to light only approximate truth. Nor is it difficult to indicate analogous persons in the higher walks of life. The most hateful and most dangerous of these people are the congenital tramps, people who did not have to work and faithfully pursued the opportunity of doing nothing. Whoever does not recognize that the world has no place for idlers and that life on God's earth must be earned by labor is without conscience. No conscientious testimony need be expected from such. Among the few rules without exception which in the course of long experience the criminalist may make, this is one, that the real tramps of both sexes in all walks of life will never testify conscientiously. Hic niger est hunc tu Romain cavedo. Section C. The correctness of testimony. The training of the witness into a capacity for truth-telling must be based on the judge's knowledge of all the conditions that affect, negatively, correct observations and reproductions, on his making clear to himself whether and which conditions are operative in the case in question, and on his aiming to eliminate this negative influence from the witness. The last is in many cases difficult, but not impossible. That mistakes have been made is generally soon noted, but then, being called and being chosen are two things, and similarly, the discovery of what is correct and the substitution of the essential observations for the opinionative ones is always the most difficult of the judge's tasks. When the witness is both unwilling to tell the truth and unable to do so, the business of training may be approached from a few common viewpoints. Patience with the witness is perhaps the most important key to success. No doubt it is difficult to be patient where there is no time, and what with our contemporary overtasking there is no time. But that must be altered. Justice must have strength to keep everybody's labor proportional to his task. A nation whose representatives do not grant money enough for this purpose must not expect satisfactory law courts. No checky, no washy, no money, no justice. People who have time will acquire patience. Patience is necessary above all while taking evidence. A great many witnesses are accustomed to say much and redundantly, and again, most criminal justices are accustomed to try to shut them off and to require brief statements. That is silly. If the witness is wandering on purpose, as many a prisoner does for definite reasons of his own, he will spread himself still more as he recognizes that his examiner does not like it. To be disagreeable is his purpose. He is never led by impatience beyond his introduction, and some piece of evidence is lost because almost every accused who speaks unintelligibly on purpose says too much in the course of his speech and brings things to light that no effort might otherwise have attained to. Besides, whoever is making a purposely long-winded testimony does not want to say anything superfluous, and if he actually does so, is unaware of it. And even when he knows that he is talking too much, most of the time he knows it from the impatient looks of his auditors, he never can tell just what exceeded the measure. If, then, he is asked to cut it short, he remains unmoved, or at most begins again at the beginning, or, if he actually condescends, he omits things of importance, perhaps even of the utmost importance. Nor must it be forgotten that at least a large proportion of such people who are brought to court have prepared their story or probably blocked it out in the rough. If they are not permitted to follow their plans, they get confused, and nothing coherent or half-coherent is discovered. And generally those who say most have thought their testimony over before. Those who merely have to say no more than yes and no at the trial do not reduce the little they are going to say to any great order. That is done only by such as have a story to tell. Once the stream of talk breaks loose, it is best allowed to flow on, and only then interrupted with appropriate questions when it threatens to become exhausting. Help against too much talk can be found in one direction, but it must be made use of before the evil begins, and is in any event of use only in the description of a long chain of events, e.g., a great brawl. There, if one has been put in complete possession of the whole truth through one or more witnesses, the next witness may be told, "Begin where X entered the room." If that is not done, one may be compelled to hear all the witness did the day before the brawl, and how these introductions, in themselves indifferent, have led to the event. But if you set the subject, the witness simply abandons the first part of possibly studied testimony without thereby losing his coherence. The procedure may be accurately observed. The witness is told, "Begin at this or that point." This deliverance is generally followed by a pause during which he obviously reviews and sets aside the part of his prepared speech dealing with the events preliminary to the required points. If, however, the setting of a starting point does not work, and the witness says he must begin at the earlier stage, let him do so. Otherwise, he tries so hard to begin according to request that, unable to go his own way, he confuses everything. The patience required for taking testimony is needful also in zero cross-examination. Not only children and slow-witted folk, but also bright persons often answer only yes and no, zero, and these bare answers demand a patience most necessary with just this bareness, if the answers are to be pursued for some time and consecutively. The danger of impatience is the more obvious, inasmuch as everyone recognizes more or less clearly that he is likely to set the reserved witness suggestive questions, and so to learn things that the witness never would have said. Not everybody, indeed, who makes monosyllabic replies in court has this nature, but in the long run, this common characteristic is manifest, and these laconic people are really not able to deliver themselves connectedly in long speeches. If, then, the witness has made only the shortest replies, and a coherent, well-composed story be made of them, the witness will, when his testimony is read to him, often not notice the untruths it might contain. He is so little accustomed to his own prolonged discourse that at most he wonders at his excellent speech without noticing even coarse falsehoods. If, contrary to expectation, he does notice them, he is too chary of words to call attention to them, assents, and is glad to see the torture coming to an end. Hence, nothing but endless patience will do to bring the laconic witness to say at least enough to make his information coherent, even though brief. It may be presented in this form for protocol. Section D. Presuppositions of evidence taking. One of the most important rules of evidence taking is not to suppose that practically any witness is skilled in statement of what he remembers. Even of child training, Froebel says, men must be drawn out, not probed. And this is the more valid in jurisprudence, and the more difficult, since the lawyers have at most only as many hours with the individual as the teacher has years. However, we must aim to draw the witness out, and if it does not work at first, we must nevertheless not despair of succeeding. The chief thing is to determine the witness's level and then meet him on it. We certainly cannot succeed, in the short time allowed us, to raise him to ours. The object of instruction, says Lang, is to endow the pupil with more apperceptive capacity, i.e., to make him intellectually free. It is therefore necessary to discover his funded thoughts and to beware of expounding too much. This is not a little true. The development of apperceptive capacity is not so difficult for us, inasmuch as our problem is not to prepare our subject for life, but for one present purpose. If we desire to this end to make one more intellectually free, we have only to get him to consider with independence the matter with which we are concerned, to keep him free of all alien suggestions and inferences, and to compel him to see the case as if no influences, personal or circumstantial, had been at work on him. This result does not require merely the setting aside of special influences, nor the setting aside of all that others have said to him on the matter under discussion, nor the elucidation of the effect of fear, of anger, of all such states of mind as might here have been operative. It requires the establishment of his unbiased vision of the subject from a period antecedent to these above-mentioned influences. Opinions, valuations, prejudices, superstitions, etc., may here be to a high degree factors of disturbance and confusion. Only when the whole Augean stable is swept out may the man be supposed capable of apperception, may the thing he is to tell us be brought to bear upon him, and he be permitted to reproduce it. This necessary preliminary is not so difficult if the second of the above-mentioned rules is observed and the funded thought of the witness is studied out. It may be said, indeed, that so long as two people converse, unaware of each other's funded thought, they speak different languages. Some of the most striking misunderstandings come from just this reason. It is not alone a matter of varying verbal values, leading to incompatible inferences. Actually, the whole of a man's mind is involved. It is generally supposed to be enough to know the meaning of the words necessary for telling a story. But such knowledge leads only to external and very superficial comprehension. Real clearness can be attained only by knowing the witness's habits of thought in regard to all the circumstances of the case. I remember vividly a case of jealous murder in which the most important witness was the victim's brother, an honest, simple woodsman, brought up in the wilderness, and in every sense far removed from idiocy. His testimony was brief, decided, and intelligent. When the motive for the murder, in this case most important, came under discussion, he shrugged his shoulders and answered my question, whether it was not committed on account of a girl, with, "Yes, so they say." On further examination, I reached the astonishing discovery that not only the word jealousy, but the very notion and comprehension of it were totally foreign to the man. The single girl he at one time thought of was won away from him without making him quarrelsome. Nobody had ever told him of the pangs and passions of other people. He had had no occasion to consider the theoretic possibility of such a thing. And so jealousy remained utterly foreign to him. It is clear that his hearing now took quite another turn. All I thought I heard from him was essentially wrong. His funded thought concerning a very important, in this case a regulative concept, had been too poor. The discovery of the funded thought is indubitably not easy, but its objective possibility with witness and accused is at least a fact. It is excluded only where it is most obviously necessary, in the case of the jury, and the impossibility in this case turns the institution of trial by jury into a utopian dream. The presiding officer of a jury court is in the best instances acquainted with a few of the jurymen, but never so far as to have been entrusted with their funded thought. Now and then, when a juryman asks a question, one gets a glimpse of it, and when the public prosecutor and the attorney for the defense make their speeches, one catches something from the jury's expressions, and then it is generally too late. Even if it be discovered earlier, nothing can be done with it. Some success is likely in the case of single individuals, but it is simply impossible to define the mental habits of 12 men with whom one has no particular relations. The third part of the Froebelian rule, to presuppose as little as possible, must be rigidly adhered to. I do not say this pessimistically, but simply because we lawyers, through endless practice, arrange the issue so much more easily, conceive its history better, and know what to exclude and what, with some degree of certainty, to retain. In consequence, we often forget our powers and present the unskilled laity, even when persons of education, too much of the material. Then it must be considered that most witnesses are uneducated, that we cannot actually descend to their level, and their unhappiness under a flood of strange material we can grasp only with difficulty. Because we do not know the witness's point of view, we ask too much of him, and therefore fail in our purpose. And if, in some exceptional case, an educated man is on the stand, we fail again, since, having the habit of dealing with the uneducated, we suppose this man to know our own specialties because he has a little education. Experience does not dispel this illusion. Whether actual training in another direction dulls the natural and free outlook we desire in the witness, or whether, in our profession, education presupposes tendencies too ideal, whatever be the reasons, it is a fact that our hardest work is generally with the most highly educated witnesses. I once had to write a protocol based on the testimony of a famous scholar who was witness in a small affair. It was a slow job. Either he did not like the terms as I dictated them, or he was doubtful of the complete certainty of this or that assertion. Let alone that I wasted an hour or two, that protocol, though rewritten, was full of corrections and erasures. And the thing turned out to be nonsense at the end. The beginning contradicted the conclusion. It was unintelligible, and still worse, untrue. As became manifest later through the indubitable testimony of many witnesses, the scholar had been so conscientious, careful, and accurate that he simply did not know what he had seen. His testimony was worthless. I have had such experiences repeatedly, and others have confessed them. To the question, where not presuppose too much, the answer is everywhere. First of all, little must be presupposed concerning people's powers of observation. They claim to have heard, seen, or felt so-and-so, and they have not seen, heard, or felt it at all, or quite differently. They assent vigorously that they have grasped, touched, counted, or examined something, and on closer examination, it is demonstrated that it was only a passing glance they threw on it. And it is still worse where something more than ordinary perception is being considered, when exceptionally keen senses or information are necessary. People trust the conventional, and when close observation is required, often lack the knowledge proper to their particular status. In this way, by presupposing a special professional knowledge in a given witness, great mistakes are made. Generally, he hasn't such knowledge, or has not made any particular use of it. In the same way, too much attention and interest are often presupposed, only to lead later to the astonishing discovery of how little attention men really pay to their own affairs. Still less, therefore, ought knowledge in less personal things be presupposed, for in the matter of real understanding, the ignorance of men far exceeds all presuppositions. Most people know the looks of all sorts of things, and think they know their essences, and when questioned, invariably assert it, quite in good faith. But if you depend on such knowledge, bad results arise that are all the more dangerous because there is rarely later opportunity to recognize their badness. As often as any new matter is discussed with a witness, it is necessary, before all, to find out his general knowledge of it, what he considers it to be, and what ideas he connects with it. If you judge that he knows nothing about it, and appraise his questions and conclusions accordingly, you will at least not go wrong in the matter, and all in all attain your end most swiftly. At the same time, it is necessary to proceed as slowly as possible. It is Carus who points out that a scholar ought not to be shown any object unless he cannot discover it or its like for himself. Each power must have developed before it can be used. Difficult as this procedure generally is, it is necessary in the teaching of children, and is there successful. It is a form of education by examples. The child is taught to assimilate to its past experience the new fact, e.g., in a comparison of some keen suffering of the child with that it made an animal suffer. Such parallels rarely fail, whether in the education of children or of witnesses. The lengthy description of an event in which, e.g., somebody is manhandled, may become quite different if the witness is brought to recall his own experience. At first, he speaks of the event as perhaps a splendid joke, but as soon as he is brought to speak of a similar situation of his own, and the two stories are set side by side, his description alters. This exemplification may be varied in many directions and is always useful. It is applicable even to accused, inasmuch as the performer himself begins to understand his deed, when it can be attached to his fully familiar inner life. The greatest skill in this matter may be exercised in the case of the jury. Connect the present new facts with similar ones they already know, and so make the matter intelligible to them. The difficulty here is again the fact that the jury is composed of strangers, and 12 in number. Finding instances familiar to them all, and familiar in such wise that they may easily link them with the case under consideration, is a rare event. If it does happen, the success is both significant and happy. It is not, however, sufficient to seek out a familiar case analogous to that under consideration. The analogy should be discovered for each event, each motive, each opinion, each reaction, each appearance, if people are to understand and follow the case. Ideas like men have an ancestry, and a knowledge of the ancestors leads to a discovery of the cousins. Section E. Egoism. It is possible that the inner character of egoism shall be as profoundly potent in legal matters as in the daily life. Goethe has experienced its effect with unparalleled keenness. Let me tell you something, he writes. Conversations with Eckermann, Vol. All periods considered regressive or transitional are subjective. Conversely, all progressive periods look outward. The whole of contemporary civilization is reactionary, because subjective. The thing of importance is everywhere the individual who is trying to show off his lordliness. Nowhere is any mentionable effort to be found that subordinates itself through love of the whole. These unmistakable terms contain a discovery that is applicable to our days even better than to Goethe's. It is characteristic of our time that each man has an exaggerated interest in himself. Consequently, he is concerned only with himself or with his immediate environment. He understands only what he already knows and feels, and he works only where he can attain some personal advantage. It is hence to be concluded that we may proceed with certainty only when we count on this exaggerated egoism and use it as a prime factor. The most insignificant little things attest this. A man who gets a printed directory will look his own name up, though he knows it is there, and contemplate it with pleasure. He does the same with the photograph of a group of which his worthy self is one of the immortalized. If personal qualities are under discussion, he is happy when he can say, "Now I am by nature so." If foreign cities are under discussion, he tells stories of his native city, or of cities that he has visited, and concerning things that can interest only him who has been there. Everyone makes an effort to bring something of his personal status to bear, either the conditions of his life or matters concerning only him. If anybody announces that he has had a good time, he means without exception, absolutely without exception, that he has had an opportunity to push his eye very forcefully into the foreground. Lazarus has rightly given this human quality historical significance. Pericles owed a considerable part of his political dictatorate to the circumstance of knowing practically all Athenian citizens by name. Hannibal, Wallenstein, Napoleon I infected their armies, thanks to ambition, with more courage than could the deepest love of arms, country, and freedom, just through knowing and calling by name the individual soldiers. Daily we get small examples of this egoism. The most disgusting and boresome witness, who is perhaps angry at having been dragged so far from his work, can be rendered valuable and useful through the initial show of a little personal interest, of some comprehension of his affairs, and of some consideration, wherever possible, of his views and efficiency. Moreover, men judge their fellows according to their comprehension of their own particular professions. The story of the peasant's sneer at a physician, "But what can he know when he does not even know how to sow oats?" is more than a story, and is true of others besides illiterate boors. Such an attitude recurs very frequently, particularly among people of engrossing trades that require much time, e.g. among soldiers, horsemen, sailors, hunters, etc.